that the POCSO Act is a special law in the regard of legislation, as it derives its root from Article 15(3) of the Constitution, where it is clearly written that state can make special laws for women and children. So in this regard, the POCSO Act, the emergence of POCSO Act was realized after the survey was conducted in the year 2007, and the data of NCRB shows that how much crime was increasing against children. The rapid increase of crime against children was the need of the hour to make such a legislation, which came in force in the year 2012. The Act, POCSO Act, the POCSO Act came in force on 14th November 2012. Now, how can we remember this date? Is very easy to remember because it is Children's Day, and it was a gift from the legislature to the children of this world, our nation, that the POCSO Act came to protect them and for the welfare of child. You know, the entire regime of the POCSO Act is the welfare of child. When you will briefly look into the provisions of POCSO Act, you can see that how the provisions are child friendly. At every stage, even at pre-trial stage or the trial stage, the provisions are so children friendly that they have protected the child at each and every stage. Be it the examination, medical examination, evidence taking, it is clearly written that no child shall be cross-examined at the trial stage. And why is it so? So that the child doesn't feel nervous when he's in camera trial, he or she, as the act is gender neutral. So here the male or female connection is no specific. The act is gender neutral. And before the coming of POCSO, I can say that before the coming of POCSO, the IPC was in force. The IPC used to protect the children from the offenses of assault, sexual assault, harassment, and all the menaces which were taking place against the children. But after the coming of POCSO, it became gender neutral. Be it male child or the female child, it protects both. In the form of sexual assault, as the preamble itself is saying, the preamble of the act itself is saying, when you take a look, an act to protect children from offenses of sexual assault, sexual harassment, and pornography, and provide for establishment of special courts. Now, what are here special courts? Special courts will be the child special courts, which will be dealing with the POCSO cases. In each and every district, there shall be special courts for the trial of POCSO offenses, the offenses which will be committed under the act of POCSO. And if there is no special court formed, then the session court of that area will try the offense as a special court. In case no special court is formed, the session court will act as a special court for the trial of offense committed under the POCSO Act. Now, as we saw that 15(3) is the main root of POCSO, but apart from that, there is another convention, there is another thing that our nation signed, the Convention on the Rights of the Child, where under Article 34 of the Convention on the Rights of the Child, under Article 34, yes, under Article 34 of the CRC, Convention on the Rights of the Child. Why is it disturbing? National, bilateral, and multilateral measures to prevent the coercion of a child to engage in any unlawful sexual activity. And when was it passed? The date is 11 December 1992. It is a very important date when the Government of India has acceded on to the Convention on the Rights of the Child adopted by the General Assembly of the United Nations. In preliminary, it can come that which organ of the United Nations, then it is General Assembly of the United Nations. So the Government of India has acceded on 11 December 1992 and signed it. So therefore, it becomes mandate for the Government of India to protect and see the welfare of child. Now, as we have seen, the background of the POCSO Act, and as we say that the Act is a gender neutral, the entire regime is child welfare, and I said that at the trial stage, pre-trial stage, every stage, the magistrate is keen to protect the child, the interest of the child, privacy of the child, confidentiality of the child. And even there is a provision under section 24(3) that the child should not be in vicinity with the accused. It means the child will not let come face the accused in any of the examination before magistrate or even otherwise. So we can see the degree that how much the court or the entire system is taking care of the child and in its assistance. And apart from that, there is rehabilitation and relief of the child under various provisions. So beginning from the initial sections, let us take an overview of the whole act in a quick manner. Starting from the preliminary part, section 1 clearly says that this act may be called the Protection of Children from Sexual Offences Act. It extends to the whole of India because after 2019 Reorganization Act, it is now applicable to Jammu and Kashmir also. And the main date which need to be remembered is that the date of enforcement is 14th November, which you can remember it as a Children's Day. So there is no problem in remembering the date of enforcement. And as far as the enactment date is concerned, it is 19th June 2012. Both these dates are important for the preliminary purpose. And what we just discussed, that under Article 34 of the CRC, as I just said, that the Government of India is bound to undertake all the appropriate measures for the welfare of child. It was said in Independent Thought versus Union of India, 2017. This case can come, Independent Thought versus Union of India. Independent Thought versus Union of India, 2017, in which it was clearly said that the Government of India is bound under Article 34 of the CRC to take all appropriate measures for the prevention of child crimes. Now, as we move further, the definition part of the POCSO Act becomes very important, as in the whole Act, these terms are discussed. And the most important part of this definition clause is the word phrase child. Who is child? The child is one who is below the age of 18 years. But here the story doesn't stop. Here it begins. Because the cases which comes in court, or the number of cases and their differentiality, is not very common. Now let us see one by one that how the determination of age will take place. Because determination of age is very necessary for the purpose of taking any act or commission of offense under the POCSO Act. So how would the age of a child would be determined? This is a primary question. Preliminary question to be solved. So in Jarnail Singh versus State of Haryana, the court said that we need to make reference to section 94 of JJ Act, Juvenile Justice, Care and Protection of Children Act, in short JJ Act. If we need to determine the age of child, we need to refer section 94 of the JJ Act. And what section 94 says? That what all factors need to be considered. First of all, the matriculation certificate. Matriculation or any equivalent certificate to it. Secondly, if there is no matriculation or equivalent certificate, then the date of birth certificate from the school attended. And even if date of birth certificate from the school cannot be obtained, then a birth certificate issued by corporation or any municipal authority, any concerned authority which is competent to issue. So it is a preferential order. You can see it is not like or. You can see it is a preferential order. If it is not there, then this. If it is not there, then this. So firstly, it is matriculation or equivalent certificate. Secondly, it is date of birth certificate issued by the school firstly attended. And thirdly, it is birth certificate issued by the corporation. And what if all these things are not there? Yes. Then we move forward to the medical test, which is known as the ossification test. If the age of the child cannot be determined by these factors, and if these factors are absent, then we have to move forward for the ossification test. In medical terminology, it is known as ossification test. Now we will not discuss that how this ossification test is done. Basically, it is done with the help of scrutinizing of bones, how old the bones are, how the formation of bones is there in the body, so that we can identify that how much the age of the person concerned or the child concerned will be. In recent case, Manoj versus State of Haryana, all these cases are very, very important for the preliminary purpose, because these are the recent cases and they can directly ask questions from these cases. That what was said by the court in so and so case. Manoj versus State of Haryana, Criminal Appeal 207 of 2022. It is a very recent case. It just came in January or February only. So what was said in this case? This court very beautifully said that ossification test is not common for all people. It is based on the individual characteristics. It differs from person to person. You are sitting there, you all are not same. The structuring of your human body is not same. So the ossification test is not uniform for all, or it cannot be like appreciable for all equally. So it is different and it is based on individual characteristics, and hence its reliability is not the pure discretion. It has to be examined in each case. Even after the test, the court has to examine it. कि जो ऑसिफिकेशन टेस्ट हुआ है, इज इट रिलायबल, ट्रस्टवर्दी, कैन वी रिलाई ऑन इट, और स्टिल देयर इज रिक्वायरमेंट ऑफ सम corroboration to see that whether the child is below the age of 18 or above the age of 18. But as the act, POCSO Act, I will repeat this line again and again throughout the lecture, that as the act is a child protecting act, child welfare act, the whole regime of the act is child welfare. So if any doubt comes in that maybe the child is of 19 years or maybe the child of 18 years, then a margin of 1 or 2 years will be given to the child. Only because the ascertainment of age cannot be done properly, or even if there is some iota of doubt that whether the child is of 18 or not, but the margin of year will be given to the child. It is not an accused protected act. In a general criminal jurisprudence, we see that the benefit of doubt or goes to the accused. It favors the accused, but here it doesn't. The court said the margin of year will be given to the child. So you can see how the POCSO Act, each and every step is protecting the child. Now, a different question came in when the consideration of child phrase was determined by the court in each and every case, that the child which is written in 2D of the act, we are here concerned with that the biological age should be 18 years. You all have read this? The biological age should be 18 years. But what if some person, due to any mental illness or any mental health problem, is of 40 years, 50 years, is an adult, but the mind of that person is like of a child? Who will protect him or her? And under which act such person will be protected? Now this question, very interesting question came, that if a person is of 30, 40, 50 years, but the mind is like of a child, 8 or 9 years, then under which act the person will be protected? Will it come under POCSO Act or will it be covered under the IPC only? In this regard, two cases came, very important. I'm discussing the aspect of child more because the probability of questions from this area is more. The first case which came was Reena Banerjee versus Nct of Delhi, 2015, 11 SCC 725. The court said, basically the court was dealing with the questions of the management of juvenile care homes, the shelter homes, the care protection homes, which are meant to protect and give shelter to children, but their condition is horrible. So the court was giving guidelines that how it should be maintained and what all measures should those homes should take in order to protect and for the welfare of child. But while discussing the same, the court said that there is no harm to include or consider the mental age of the child with the biological age. There is no harm. We won't be going to the contrary of the legislation if we will include the mental age with the biological age. It means if a person is of 40 years of age and having a mind like of a child, which is like 7 or 8 years of age, then there is no harm in treating him or her as a child. But another case came in 2017, Ira Manjula. It is a very, very important case. Krippendorf versus Nct of Delhi. AIR 2017 SC 3457. This was the case which came in the year 2017, and it gave a very different opinion. The Supreme Court gave a very different opinion in this case. Miss Aishwarya Bharti was the senior advocate in this case, and a time back I had a word with her because as I was reading POCSO and I had this case in mind, so I was talking to her that, ma'am, what happened in that case? What actually happened in that case? And why the court could not consider this, the legislation part in a broader manner? Because what was said in this case that the judges concerned are Justice Deepak Mishra, and Justice Rohinton Nariman. In this case, court refused to consider the mental age with the biological age. Basically, they did not consider a person with mental age of a child with the biological age of a child. They said, what they actually said, that it was clear, viewed with the lens of the legislature, that it would be a violence both to the intent and the language of parliament if one would read the word mental into section 21D of the act. It means you cannot read the mental age with the biological age. The court refused, overruled what was said in Reena Banerjee. And as far as my personal opinion is concerned, I am not agreed with this decision of court. Because a person, man, female, whoever, if it is of age 40 years, but the mind is like of a 7 or 8 years, then how would the person know the gravity of offense which is being committed against him or her? And how would you testify the person? How will the examination take place? When the lady which was a victim under this case was of 38 years of age, and when she was standing in the court, she was nervous like a child of 6 to 7 years, as if where I am standing and why they have made me to stand here and what all they are going to ask me. She was fumbling. And when the lawyers involved said that she should be treated as a child, as her mental age is like of a child, but the court refused. So maybe a different perspective will be taken in future, definitely, because this is not going to last for so long, I feel so. But for the examination purpose, we need to remember this case, that in ERA, it was said that biological age does not include mental age. We all here who are sitting belong to the legal fraternity. And in past times, Supreme Court has said many times that the fundamental rights which are there in the Constitution are like empty vessels. And they need to be filled after every generation crossing according to their wisdom. Because law cannot be stagnant. It needs to be filled with each and every generation coming up. The law which was 50 years back cannot retain in today's time. It needs to be changed as per the need of the hour. If the crime against children would not have increased, the POCSO Act would not have come into force. You yourself can see that in the past 4 or 5 years, how much we are dealing with the POCSO Act, and earlier we were not. When you joined your law schools, when you were in the first year, I don't think so, you did not even have a even a discussion about the POCSO Act, that a case has come in POCSO Act or something has happened under it. But now it is like 4 cases, 5 cases out of 10. And what is the reason behind? Were not the crimes happening earlier? The awareness has increased. People have become aware of their rights. Now they know that they can get their children justice. So this was the theory and chronology of child. Now after moving towards the section 3, that is penetrative sexual assault. So for the penetrative sexual assault, it is similar to the what is written in IPC. If someone penetrates, you can mark the words which you need to remember in a particular section. Penetrates, inserts, manipulates, and applies his mouth. These are the 4 major words which you need to remember in the penetrative sexual assault under section 3. And here we should know that the consent of the child is immaterial if he is below the age of 18 years. So the consent is immaterial. You can write down there only. The consent is immaterial if the child is below the age of 18 years. And even under Muslim law, if a girl child, because at the age of 15, the age of puberty is considered, even if she is married against her wish, but if she says no, then it is covered under the POCSO Act. It is the beauty of Act. It was said in Rahul versus State of Karnataka. The case name is Rahul versus State of Karnataka, in which the person concerned enticed the girl and married her against her wish and sexually assaulted her. So the person was liable under this act, though he was married to her. So the consent of minor girl is immaterial. The punishment for penetrative sexual assault is given under section 4, and it says that in general the punishment shall not be less than 10 years but may extend to life imprisonment. But if a person commits the sexual assault with the child of below 16 years of age, then it is then it shall extend to 20 years and extend to imprisonment for life. So it is almost double. General 10 years, and if it is below the child of 16 years, then it is 20 years extending to life imprisonment. In case of Sunil Raikwar, it is a very good case on this section 4. Sunil Raikwar versus State, 2021, 1 RCR, Criminal 883. Generally, there is a tendency of settling the cases, crimes, that if some settlement happens, then let us just go with the case. But in this case, the court said that father of the victim cannot be permitted to settle the dispute with the accused. No leniency should be shown to the accused if he has committed crime against the POCSO Act. He is not the victim. The father is not the victim. And the courts have to safeguard and protect the interest of children against onslaught by bad forces. It is also a recent case in which court said that no leniency should be shown to the accused. And you know what is the origin of this no leniency? That why the court is again and again saying that the accused should not be favored, accused should not be benefited, interest of the child should be taken at preference state. We get this clue from section 29. If we move towards section 29, where it is said that when a person is prosecuted for committing any offense under 3579 of the Act, the special court shall presume. The word used is shall presume that such person has committed. So basically it is a rebuttable presumption of law. it is a rebuttable presumption of law that a crime has been committed, and now it is upon the accused to prove that I have not committed the crime. So in this regard, section 29 of the Act becomes very important, where it says that the court shall presume that the act has committed. Now you, the accused person, need to prove that you have not committed or abetted this crime or even attempted this crime. Now in section 5, as we read penetrative sexual assault in section 3, when certain factors gets involved in the penetrative sexual assault and make it an aggravated form. Now what is the aggravating factor? Aggravating factor is, it is presumed that a child is secured with its family. A child is secured in the presence of the person whom he believes in, trusts in. But when such and such persons or authorities commit crime, sexual crime against child, then it becomes an aggravating factor. If a father himself sexually assaults his or her child, then what more than can be an aggravating factor? Nothing more than can become an aggravating factor in this regard. Whom to believe in? So there are certain factors that if a assault, harassment has committed by a person who is under authority, even hospital authorities, school authorities, relative of the child, gang sexual assault below the child of 12 years, knowing that the child is pregnant, making the child pregnant, attempts to murder. There are many factors which are given here in section 5, which makes the offense aggravated. Inflicts the child with human immunodeficiency virus, causes the death of child, is in a position of trust or authority. So all these things makes a crime aggravated. An aggravating factor attaches to it. And what aggravating factor is basically doing? It is increasing the degree of crime. The crime which is happening, the unknown person is committing a crime, but when a known person is committing a crime, when we listen this fact that a father has assaulted his or her child, how bad we feel. That then after all, where the child will feel protected? At his home only. But if the home itself is not protected, then where the child will go? And in this regard, under section 19, the guidelines have been given to the SJPU and to the police also. What is there in section 19? Firstly, read that only. This section 19 mandates, they have used the word shall. Section 19 mandates that if any person has apprehension, two terms have been used in section 19. Apprehension and knowledge. If a person is having apprehension that a crime is going to be committed, then he should inform the concerned authority, special juvenile police unit or the local police. And if a person has a knowledge that a crime has committed, then also it becomes mandatory for him to inform. Either to the SJPU, special juvenile police unit, or the local police. And then the procedure of 154 will follow up. Section 154 CRPC. The writing of FIR, reading of information to the informant, the content should be entered in a book. Everything will follow as like of CRPC. Now, in case the child is not able to clearly express that what has happened to him or her, then a special interpreter, educator, any instructor can be appointed, and it shall the concerned person shall be appointed by the state government at the expenses of state government. So it can come a question in preliminary also that who is going to appoint the interpreter, translator, then the state government is going to appoint. It is a preliminary question. And the payment of the interpreter shall also be made by the state government at the expenses. Yes. 19. In 19, we don't only read section 19. Along with it, the rules are also need to be read. But I am not taking you to the rules because it can confuse you. The rules of 2020 have made it clear. And while, registering the offense, while writing the case, if the SJPU or police is satisfied that the child who has come to them or the information which has been given to the SJPU, if needs special care, protection, the urgent need, there is an urgent need, then the SJPU will record the reasons in writing and shall give it to the CWC, Child Welfare Committee. They will make a report that the child needs urgent care and protection. They will prepare a report within 24 hours. They will prepare a report. Because the process need to be done as early as possible. It has the purpose of POCSO Act is not an elongated trial. Even there is a provision that the whole trial of the POCSO Act should be completed at max of 1 year. As early as possible. Because here the victim person is child. The most vulnerable section of society. Even if the even if the child gets justice in the court, still the scar of that offense, that crime remains with the child. And that is why there is need of these interpreters, the special educators, or the counselors who can counsel with the child. That too at the expense of state government. So if there is an urgent need that within 24 hours, the SDPU or the local police will prepare a report and give to Child Welfare Committee, and then the Child Welfare Committee, according to section 31 of JJ Act, CWC, according to section 31 of JJ Act, shall determine within 3 days. These time durations are very important, that after getting report from SJPU or local police, the CWC, Child Welfare Committee, within 3 days will determine that whether the child actually needs the urgent care and protection or not. And if yes, then they will provide the child to the shelter home, care protection home, whichever is available or possible. And in this regard, even if the SJPU feels that the child is not even safe in the shared household where he or she is residing presently, then also the household of the child can be shifted. Because if the perpetrator or if the offender is relative itself, then the child won't be allowed to stay with the person or the shared household in which he or she is residing. So that can also be changed. And this is written in Rule 4. All this part is written in Rule 4 of 2020 rules. If, and after receiving report within 24 hours, if the child is injured, there are some scars and it needs medical attention, then the medical practitioner shall be approached, and the medical practitioner, after examining the child medically, shall prepare a report and submit it within, again, 24 hours. The medical report shall also be submitted within 24 hours. And when the medical board or practitioner will submit a report, then the SJPU will pass over that report to CWC and the magistrate, the special court, within 24 hours. So it is a whole process of 3 days, as early as possible. After receiving the report from the medical practitioner, the report shall be given to the CWC and the special court. And special court is here is, if the special court is made, then it is all right, if the state government has made. But if there is no special court, then the session court of that area will be considered as the special court, so that the trial can begin and further proceedings can take place. All these things are written in section 19, which is a very important section, that reporting of offense is mandatory. We discussed the aggravated penetrative sexual assault. Now it is an important section which was in news past days, which is section 7, sexual assault. It is sexual assault. In this section, the main keywords is sexual intent, the reading of section 7, whoever with sexual intent touches the vagina, the pivotal parts, and make the child do so, or does any other act. It means whatever is written in the first line. Apart from that, even if he is doing any other act with the sexual intent, which involves physical contact, but without penetration. It is very important. Firstly, it is elaborating that if a person is touching the pivotal parts with the sexual intent, it is sexual assault. But if he is doing or she is doing any other act with the sexual intent, and that too without penetration, but is including the physical contact, then also it is sexual assault. Then also it is sexual assault. And in that regard, very two famous cases are in consideration. Firstly, we will see Satish Ragde versus State of Maharashtra. Satish Ragde versus State of Maharashtra. It was a Bombay High Court judgment. Many of you must be familiar with the judgment because it was a very sensational judgment. It was given by a very famous judge, Justice Pushpa Ganediwala. And after giving this judgment, as per the latest news, she has not even been recommended for getting permanent. You know, many things happen even in judicial career also. Giving of right judgment is very essential. Ignoring of essential fact is a different thing. But ignoring it intentionally can take you to any place which you have not even desired of or aspired of. What the main crux of this case, as it was said that the act of pressing of the breast of child without any specific details is not included in sexual assault. So very good line was written in this case that if a person is committing a crime or sexually assaulting a child by wearing gloves, then it means he is not sexually assaulting the child. Why? Because there was no skin-to-skin contact. The court very beautifully said, the another case which was in consideration was Attorney General for India, because we will read these cases together. Attorney General for India versus Satish and another, in which this Satish ruling was overruled. AIR 2022 SC 13. In this case, the court overruled what was held in Satish Ragade, because in Satish Ragade it was said that as there is no specification of the offense committed, and the act of pressing of breast of the child won't be included in sexual assault because there is no specification whether the top or the cloth of the child was removed or not. So, because there was absence of specification, we won't include this act under the act of sexual assault, which was really disturbing for all the people who were reading this judgment. And finally, in Attorney General for India versus Satish and another 2022 SC 13, the court finally said that it means the judgment which you have delivered gives us a very clear insight that if a person is wearing gloves and sexually assaulting the child, and as there is no skin-to-skin contact between the child and the perpetrator, the offender, the crime of sexual assault has not happened, because he is not touching his hands to the child body parts. So any person can escape from his liability by wearing gloves and committing the crime. So in Attorney General, it was said that skin-to-skin touch is not mandatory. It is the sexual intent. It is the sexual intent of the accused which is necessary for the offense of sexual assault. Sexual assault के crime के लिए sexual intent necessary है, skin-to-skin touch नहीं. So in Attorney General, the court overruled what was said in Satish Ragade versus State of Maharashtra. The court said that any narrow interpretation of such offense or any provision of the act will defeat the purpose of and the objective of this act. Any narrow interpretation. If we will do such narrow interpretation of sexual assault or even any other provision of this act, it will lead us, all of us, to a detrimental situation. Because the framing of object will be negated. The real intent of the legislature will be negated. It was meant to protect the child, and here he is getting a pipeline to escape. That, okay, Mr. R was wearing gloves, or he actually didn't touch the body parts of the child, so okay, let him go. So this was the outcome of Satish Ragade. But finally, the will of the jurisprudence did not let this remain forever, and it got overruled in Attorney General. So it is now clear that it is the sexual intent which is necessary and not the skin-to-skin contact. These two cases can come in preliminary for sure. Now, the punishment for sexual assault is given under Section 8. The area how we can remember these sections is, starting from Section 3, it is penetrative sexual assault. Then after it, it is punishment. Then in 5, it is aggravated form. So here we can remember like this. And then in Section 7, it is sexual assault, and thereafter it's punishment. So it is a very series of chronology. So for the punishment for sexual assault, it is minimum 3 years and maximum 5 years along with the fine. Then in 9, it comes aggravated sexual assault, and again, how the sexual assault becomes aggravated is the aggravating factor, as we have read in Section 5, that if it has been done by any police officer, any management authority, gang sexual assault, using deadly weapons, grievous hurt, making the child mentally or physically disabled below the age of 12 years, knowing the child is pregnant, attempting to murder the child or murders the child, causes the death of the child, all these factors makes the crime aggravated. So in Section 9, it is aggravated sexual assault, and the punishment for the same is given under Section 10, which is minimum 5 years and it can extend to 7 years along with the fine. Here you can see that in most of the crimes which we read in IPC, there is generally punishment or fine or both. But as you can see in POCSO Act, it is and fine. Because the compensatory part, the rehabilitation part, the relief part has been made mandatory to be given to the child. After all, the crime has been committed against the child. Now, in 11 comes the sexual harassment, which we even read in IPC also, that what is sexual harassment? If any person with sexual intent utters any word, the word which need to be remembered for sexual harassment is utters any word, you can mark it, utters any word, sound, gesture, exhibits any object or part of the body with the intention that such sound, gesture or exhibit can be seen, heard or felt. So the main words are sexual intent, word, sound, gesture or exhibits. If in any of these forms a person does any act, then he is said to commit sexual harassment with the child. And whether there was sexual intent or not, even in section 7 or here, it is a question of fact. That whether it was done with the sexual intent or not. Because it can be a medical examination also. In medical examination, a doctor can do such things which can come under the purview of sexual assault, but that won't be included in sexual assault or harassment. There are certain areas where a person committing doing an operation or any medical examination can touch the parts of the child even compulsorily without his consent also, because that is necessary for his or her treatment, but that won't be included to sexual assault. So certain areas are exempted. That is why the concept of sexual intent is a question of fact that has to be seen with these circumstantial facts, the surrounding facts. The punishment for sexual harassment is given under section 12, which is up to 3 years and fine. Now the section 13 comes for the pornography. If any person uses the child for the pornographic purpose in any form of media, by the advertisement, television program, channel, internet, electronic form, any of the form, printed, if a person uses child for the pornographic purpose, represents the sexual organs of the child, indecent or obscene representation of a child, then a person shall be punished for such in section 14. A case came in 2021. It was a line attracted me more for adding that case. The case name was PG Sam Infant Jones versus State, 2021. What the court said in this case? The court said that apart from making provisions for the protection of child, for prevention of crime against child, the Indian Bharatiya culture can act as a bulwark for preventing such crimes. The Indian Bharatiya culture can act as a bulwark for prevention of this crime. Because it is not the provision which is going to prevent the crime. It is the mental status of a person which will prevent the crime. The mental status, the mental intention need to be changed. It is the mentality which need to be changed for preventing any crime, be it against a child or against an adult person. Even if a rape is committed, the mental intention need to be seen. It is more the psychological factor. The psychologists say that it is 30% the psychological factor which is involved in the commission of offenses like rape. And what all things impact a person? The major role plays with the pornography. Study it has showed. But the culture which we follow in India, the respect which we showed, the goddess which we pray, all this factors realizes us, makes us think that how these crimes can be prevented. The moral education which a child gets from his home acts as a bulwark. The parenting, the teachers, the role of teachers, the role of your elders. So they play more role than these provisions, because these provisions will come into role when the crime has committed. But all these things will play their role in the beginning years of the child or any person who afterwards become an offender. So very beautiful line was said by the court that it is only the Bharatiya culture that can act as a bulwark. And a phrase was used. Sometimes the phrases of a case can come in exam and they can ask that who used this phrase, which judge used this phrase. So it is the tendency of DJs that they can ask such and such questions. So a phrase was used that the pipe is sweet. Heard it carefully. Hear it carefully. Pipe is sweet, the lute is sweet. And say those who have not heard the prattle of their own children. The pipe is sweet, the lute is sweet, and say those who have not heard the prattle of their own children. Now, what was the expansive interpretation? What is the expansion of this line? It means that you not only think of your own children, that my children are very sweet, they are protected because we have kept them in a very safe cage under our parenting, but it is all the children of this world need to be protected. And this line again takes us to section 19. How? That if you are treating all the children like your own children, then you will protect them as yours. And if anything happens against them, then it is your duty, a mandatory duty, to inform the concerned authority that a crime has been committed against child. Again, this line is somewhere indirectly saying that the reporting of offense is mandatory. If you see that a crime is committing or happening against a child, then you should prevent. And even if you can't prevent, then just at least report. Don't escape from reporting these offenses. That is very necessary for the development of child, the mental development of child. The section 14 of the Act provides punishment for the pornography, and if any person uses a child for pornographic purpose, then it shall be punished with 5 years and fine, and if he do that subsequently, then it is 7 years and fine. And if a person who is using a child for pornography commits an offense while using child for pornography, then in addition to this, he shall be punished for the said offenses under the section 4, 6 and 8 as whatever crime he commits, according and in addition with the subsection 1. It means he will be punished for 5 years and fine, and along with the punishment for the offense which he has committed. So it is in addition to. Then in section 15, again, it is punishment for storage of pornographic material, and the punishments are given likewise. 500 rupees for storing, 5,000 for storing, and if second conviction goes on take place, then it is 10,000. And if any person stores and transmits, firstly thing is storing, and even if after storing he transmits, then it is up to 3 years or fine or both. And if any person who is storing and involving a child for commercial purpose, then it is 3 years to 5 years or fine or both. And on second conviction, it is 5 years to 7 years and fine. So it has made it a stricter punishment for storing pornographic material or transmitting the same. Now in section 16, it is abatement, which we read in IPC, like section 107 of IPC, that how the abatement takes place. It takes place with 3 things: instigation, conspiracy, and intentionally aiding. The same goes with the POCSO Act also. If a person abets any person to do such act, to do such crime, which crime? Sexual assault, harassment, penetrative sexual assault. If any of such act has been committed in the light of abatement, then the person abetting shall be punished. Punishment for abatement has been given under section 17. Whoever abets any offense under this act, if the act is committed, now see, there is a line which we need to read properly. In IPC, the offense of abatement is individually an offense. But here what it is written in section 17 is, whoever abets any offense under this act, if the act abated is committed in consequence of the abatement, then he shall be punished with punishment for that offense. It means here the consequence is seen, but in IPC the consequence is not seen. The act of commission of abatement is enough for the offense. Means abatement is itself an offense. But here they are writing that after the abatement, the consequence, the act of offense must be done. But that doesn't mean that the person can't be punished under IPC. Escape नहीं मिल रहा है. But हमें POCSO को ध्यान से देखना है. So here we have to see that the consequence is required here. Because when we are going for preliminary, we need to see these words can actually confuse the mind. Because what we have read in IPC, consequence is not required. So with that dilemma, we can take the option that consequence is not required. But here in the POCSO Act, it is written that it is when it is committed in consequence of the instigation or whichever means the abatement has been done. So it becomes important to read this line carefully. Now the punishment for attempt to commit an offense is given under section 18. It is any term to 1/2 of the life imprisonment or 1/2 of the longest term of imprisonment, whichever is provided for the offense. Section 19 we have already read, reporting of offenses. The reporting of offenses is mandatory, not directory. It is mandatory because the word shall has been used, and mostly the time duration for reporting of offense, going to the medical practitioner, then the medical report to be submitted to the special court, all these durations are 24 hours. So we can generally remember that it is 24 hours and no other duration is given here which can be or which has to be remembered otherwise. Now in section 21, it is punishment for failure to report or record a case. If any person fails to report under section 19, then he shall be punished under section 21 for 6 months or fine or both. But if a person is in charge of any company, institution, and then he fails to report, then he shall be punished with imprisonment for a term which may extend to 1 year. Because after Vishakha guidelines also, it has become mandatory for every institution to organize a cell for women also, that no harassment takes place against women. So the internal redressal committee has been formed. So if the institution itself won't report the commission of crime, then from whom we can expect? The other person can escape, but if the institution itself is escaping, then what to expect from others? So that is why the punishment, the degree of punishment for the institutional, the company part has increased, and they shall be punished for 1 year or and fine. And if any person falsely complains or provides false information, then he shall be punished with 6 months or fine or both. But if a false complaint has been filed by a child, it is a preliminary question, then there is no punishment. Because child is an exceptional part. He may be manipulated for giving false information, or he may in his intelligence, that if something has happened, so he can say it likewise according to his intelligence, his or her intelligence. So there is no punishment for the child to give false information or any false complaint. But if a person against a child gives false informations, who not being a child makes a false complaint against a child, then he shall be punished to 1 year or with fine or both. Now, as we know that the whole regime of the POCSO Act is the individuality, the protection of the individuality of the child, there is a procedure that the identity of the child shall not be revealed. It is given in section 23 that the identity of the child shall not be revealed at any stage. But if the special court feels that it is for the betterment of child or it is for the interest of the child that such information can be revealed, then the special court may permit. So it is the discretion of special court to permit for the disclosure of the identity of the child. But as a general rule, the identity of the child cannot be disclosed or revealed. In 24, there is recording of statement of child, and the recording of statement shall be recorded within a period of 30 days, as it is written down in section 35. The 24 need to be read with section 35, and the recording of statement shall be done within a period of 30 days at the residence of child or wherever the child feels safe. Now, what all things need to be remembered when the statement of the child is recorded? That the person who is recording the statement, if it is a policeman or any other officer, then he should not be in uniform. And why he should not be in uniform? So that the child don't feel insecure that why he is talking to a police, because a child knows that he is a police uncle and why he is sitting next to me, what all he is asking to me. So the person concerned who is recording the statement of the child should talk in a friendly manner with the child, so that the child doesn't feel that I am getting examined or I am getting testified. So this is the reason the person concerned should not be in the uniform. And in no way, as I said earlier, the child should not come in the vicinity of the accused. It is written in clause 3, 24 clause 3, that at no point of time the child come in the contact of the accused, because the accused may in a mental or any other manner harm the child. And a child shall not be detained in the police station in the night for any reason. Okay, so all these things are very crucial for the when the statement or recording of statement of child is taking place. And there is even a provision that if the statement of child requires any assistance of interpreter, then that can also be taken care of. And frequent breaks for the child during the trial, so that the child doesn't feel obviously tired or anything. So child frequent breaks for the child during the trial has to be taken care of, and absolutely not to be testified repeatedly. In general sense, in CRPC, we can call or examine witnesses or accused again and again. We can call them, we can issue summon warrant and call them again and again in the court. But likewise, a child cannot be examined repeatedly. It is against the interest of the child. So it cannot be called in court again and again. Now, when the statement of child shall be recorded by the magistrate, it will be done as per section 164 of CRPC. But one thing which is written in 164 CRPC is when the statement is getting recorded, the lawyer of the accused. But in 164 it is his presence is permissible, his presence is required. But here, when the statement of child is getting recorded, the lawyer of the accused shall not be present before the child or even the accused. So it is provided that the statement shall be recorded as per 164 CRPC, but the presence of the accused or the lawyer of the accused shall not be there before the child. So it is very important provision, section 24, 25, when the recording of statement of child is going on. In section 27, there is medical examination of child, and medical examination of the child shall be same as per 164A CRPC. It shall be conducted in the presence of parent of the child or the person in whom he reposes trust or confidence. And if it is a female child, then the person who is conducting the medical examination shall be a women doctor. It is understood ipso facto that if a female child is getting examined, then a presence of women doctor or women medical practitioner is required. Now, the designation of special courts under section 28, the state government with the consultation of Chief Justice of High Court. Again, a preliminary question, that the state government with the consultation of Chief Justice of High Court designate for each district a court of session to be a special court. As I said in the beginning also, that the session court of the area shall construe as special court to try the offense under this act. And even if there is any crime which has been committed under this act involves the trial of other offenses like of IT Act, because the pornographic material can also be in electronic form, the transmission. So all these can include the IT sections. So if any crime has been committed in this act but is including the crimes in other areas of law also, then it does not oust the jurisdiction of that special court to try that offense. All these offenses can be tried together. Section 29, we have already discussed. It is a very important section, that the court shall presume that the offense has been committed. Generally, it is the prosecution, the complainant, which need to prove that the act has been committed. The onus, the burden of proof is on the complainant to prove that a crime has been committed. But in the POCSO Act, the court shall believe that a crime has been committed against a child, and it is now for the accused to prove that I have not committed this crime. So the presumption is shall presume. It is a rebuttable presumption of law. If accused succeeds in proving that I have not committed the crime, then the presumption shall be rebutted. So it is a rebuttable presumption of law. Then section 33 is important. A special court may take cognizance of any offense, and in subsection 2 it is written that the cross examination shall not be done with the child. If any questions need to be asked to the child, then the lawyer, the counsel can give his questions to the court, the magistrate, and the magistrate will himself ask the questions to the child. But there shall be no direct contact of the other lawyer with the child. The special court may permit frequent breaks, shall create a friendly atmosphere, shall ensure that the child is not repeatedly called to testify, and not permit aggressive questioning. The 8th point is very important in this regard, that the special court may, in addition to the punishment, direct payment of compensation. Here is the compensatory part under this act, that the court shall provide compensation to the child for any physical or mental trauma faced. And who will pay the compensation? State government will pay the compensation. When the special court will order that a compensation has to be made to the child, the state government shall pay that compensation. To whichever extent the compensation has been ordered, the state government shall pay within 30 days. Compensation need to be made within 30 days of order. As soon as the court orders, from the date of passing of order by the court, the state government shall pay it within 30 days to the child. And the compensation is not prescribed. It will depend upon the case, the trauma faced by the child, with circumstances he has or she has gone through. Likewise, the compensation shall be decided by the special court. And the compensation shall be paid by the state government from the Victim Compensation Fund. Now in 34, section 34, it is again the determination of age. So when we read to the child in the definition clause, then section 34 is read along with it, that how the age has to be determined by the court. And the procedure is same. Matriculation certificate, in its absence, date of birth, the date of birth certificate from the school, and in its absence, date of birth certificate by any corporation, municipal authority. And if all these three factors are absent, then ossification test, a medical test can be done to ascertain that what is the age of the child. Now, preliminary question is that when the age has to be determined by the ossification test, by when the committee will order or the board will order, what was the section which we had to refer? 34 or 94? 94. 94. So it was 94. 34 was the when the child needs urgent care, protection. Okay, 94 is when the determination of age has to be taken place. So section 94, referring to section 94 of JJ Act, when the ossification test has to be done, then the test shall be completed within 15 days from that order. If there is requirement of doing ossification test in order to determine that what is the age of the child, so the ossification test shall be conducted within 15 days from the date of order. In section 35, I've already discussed when I was mentioning the recording of evidence that it has to be done within a period of 30 days, and as far as possible, the trial has to be completed within 1 year from the date of cognizance of the offense, because it is very necessary to dispose of the trial under the POCSO Act as early as possible. In 37, they says that the trial has to be conducted in camera. It means the confidentiality of the child, the privacy of the child has to be upheld. So that is why the trial need to be conducted in camera. Now in section 40, in 38 there is an important factor for the preliminary purpose. We all know that the assistance of interpreter or expert can be taken while the recording of evidence of child. But any interpreter or translator, special educator, if is appointed under the act for the child, then the same rules of confidentiality shall be applied to him as it is applied under section 126 and 127 of Indian Evidence Act. The same rules of confidentiality shall apply. It means if the child is disclosing any information to that educator, that interpreter, then that interpreter cannot disclose that information to any other third person except the magistrate. So the rules of confidentiality as laid down in 126 and 127 of Indian Evidence Act, the same rules shall apply here for that educator. In section 40, they have said that the assistance of legal practitioner can be taken. Where is the legal aid provision given under CRPC? Where is the legal aid provision provided under CRPC? 301, 303, 304. Yes. And right of take assistance of legal practitioner. So the legal aid is given in 304, and the assistance or aid from taking legal practitioner, the right of taking help from legal practitioner is given under 303 of CRPC. So here in 40, the right of child to take assistance of legal practitioner of any choice which he wants, and the legal aid and assistance shall be provided to the child in accordance with the Legal Services Authorities Act 1987. If any legal aid is provided to the child, then it shall be in accordance with the Legal Services Authority Act. And who shall recommend? Who's the authority to recommend? The Child Welfare Committee will make a recommendation to the District Legal Services Authority that a child needs legal aid and assistance. Therefore, special measures should be taken by the authority to give the child legal assistance. So the CWC will make recommendation to whom? District Legal Services Authority, and then the legal aid shall be given to the child as per Legal Services Authority Act. You all must have heard about the interim relief. Interim relief can be given during the proceedings, during the trial, whenever it is required. Likewise, interim relief or interim urgency, if required by the child, then that can also be given to the child within a week. If CWC feels that there is urgent relief or compensation is required to the child, then they can make an order, and after making an order, the payment shall be made to the child within a week of such order. Within a week of such order or recommendation. If there is requirement of immediate payment for assistance to the child, then the CWC can make recommendation and the payment shall be made to the child within a week of that order. As I was saying, that in certain cases, the provisions of section 3, 5, 7, 11 doesn't apply. Here they have written in section 41 that when they do not apply. When a child is getting medically treated or medical examination or treatment is undertaken, then the provisions of section 3, 5 or the offenses which have been prescribed here does not get attracted. A very good point is given under section 42. Generally, it is when 2 or more punishments are there, then it is either the discretion of the court that what of punishment should be given to the accused, or the lesser punishment is generally given to the accused, because the benefit always goes to the accused also. It is not that if he has committed crime, then he has become an evil for the society. Because in India, we follow the reformative theory and not the deterrent theory. We believe in the reformation of the accused. It is the evil which has to be eradicated and not the person. But here in section 42, they have written that if any offender has been found guilty of any offense under this act or the Indian Penal Code, then the punishment which shall be given to the offender will be the greater in degree. It means if the IPC is providing 5 years and POCSO is providing 7 years, then the 7 years will be given to the accused. The punishment which shall be greater in degree. So that is also a different thing which is there in POCSO Act, apart from the other criminal laws. And in case of any redundancy, any contradiction between two laws, because all the laws are interconnected, IPC is always read if there is a criminal law. So if there is any redundancy, any contradiction between 2 or 3 laws, then always the POCSO Act will prevail. Although the POCSO Act is in addition to other laws, POCSO Act doesn't say that I'm in contradiction to you. POCSO Act says that I'm helping you more specifically. Because earlier in IPC, there were few crimes in which only the woman was protected. But in POCSO, even the male child is protected. Because it is a gender neutral law. There used to be a debate in IPC that why a male child is not protected in the offense of rape. Although he includes she also. But there used to be a lot of debate that why a male child, a male person is not included in the offense of rape. So here we have come with the special law of POCSO, which says that I am a gender neutral law and I protect the male child and female child both. I do not discriminate in any person, be it male child or female child. So I am in addition to the other laws. I have come to help them. I have come as an extended hand of those laws. But if any contradiction takes place between me and other laws, then it is me who will prevail. So it is the POCSO Act who will prevail. So it is clear to all that POCSO Act has come as a special legislation. Its roots are from 15(3) of the Constitution, 34 of CRC, Convention on Child Rights Act. There has been a declaration which has signed by the Government of India on 11 December 1992. It is a very important date when the Government of India acceded to that right. Because now it is bound to undertake all measures after signing that treaty. We have acceded to that right on 11 December 1992, adopted by the General Assembly in United Nations. So now the Government of India is bound. There are certain principles which are discretionary for the state to take. But as far as the POCSO Act is concerned, it is now has become a legislation. So now it has become a paramount duty of state to protect and uphold the welfare of child. So I believe that you have understood and got an overview of all the sections, all the relevant and major portions of POCSO Act in this period of 2 hours or 1.5 hours. As it is a discussion class and a pre-oriented class, so each and every section cannot be going into much detail, but I've tried my best to include every essential point which can be discussed in a particular section for the preliminary purpose and give you an insight that what is important for a relevant section to be read on. And now I feel that if you will revise the Bare Act, if you will read the lines carefully, you will get through the Act with utmost confidence. That yes, I have get the root, the ulterior motive of legislation, what they intended to serve in this Act. So I hope this was clear to you, and all the major case laws are very important. And as far as each section is concerned, I've tried to give you the names of important decisions given by the court in recent times, be it Satesh, Ragre, Attorney General, Libnes. Every case is very important. At least there are 8 to 10 major case laws that need to be read before going to the examination hall. So please read them carefully. At least remember the crux, what was said in that case. So that is all for the POCSO Act. And I wish you all the best for your exam. Thank you, everyone.